Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. And I am, of course, Attorney Andrew Branca for the Law of Self-Defense. Thank you very, very much. We had an of topic for today. I had planned to finish my reading of Duncan v. Bonta, which is the Fifth Circuit District Court decision finding that California's standard capacity magazine ban is unconstitutional. We read the first half of that yesterday. I was going to complete that today, but then we have some breaking news and some interesting video to go over. And that is the breaking news, of course, is the judge in Philadelphia dismissing murder and other charges against former Philadelphia police officer Mark Dial in his shooting of a criminal suspect back in August. The result, of course, has been what you might expect in Philadelphia, lots and lots of looting. Just a quick search on YouTube, and it's looting, rioting, looting, destruction, fire, arson, looting, riot, looting, and arson. You know, it's funny. It's, I mean, of course, it's not funny, but it would be remarkable if Law of Self-Defense had a dedicated course on exactly this topic, how to defend yourself amidst riot, looting, and arson, right there at the bottom of the screen, folks. lawofselfdefense.com/RLA for riot, looting, and arson, DVD and online streamed. Just saying, this might be useful stuff for you to know, particularly if you live in a city. But Philadelphia is on fire, being looted, being ransacked by opportunistic mobs over the breaking news that this police officer, Mark Dial, his criminal charges have been dismissed by a judge. By the way, they could come back. There's a path of appeal for the prosecution here that the prosecution, a George Soros prosecutor in Philadelphia, of course, says he intends to pursue. But what we'll talk about today is not so much the riots. They're just happening. Sorry for you in Philadelphia. Live someplace else, I guess. But the shooting itself. So I have the body-worn camera of the two officers involved in the stop of the suspect here, only one of whom fired shots and was facing criminal liability. But I have both their body cameras, only the first one, only the shooter's body camera is really interesting. So I'm not sure we'll spend time going over the other officers. And I have footage of a nearby surveillance camera that captured the shooting as well. So we'll look at those videos and see to what extent the videos are consistent with what's being argued by the prosecution, by the defense, and on Twitter, X. I see lots of claims being made on X that are, whether intentionally or just as a function of human nature, are already building a propaganda narrative around this event. Things that are either irrelevant or untrue representations. And we know they're untrue because we've got the video, which is what we will be watching today. So with that out of the way, that little introductory segment, let's jump into the proper portion of today's show. Here we go. All right, folks. So let's talk about what's going on in Philadelphia. I do have a couple of news reports I wanted to share, but of course I forgot to prep them properly. Hold on, give me 1 second, folks. Nothing but the highest production values here at Law Self-Defense. I know that's why you're all here. It should be a pretty quick show, I think, for me at least. Okay, that's one. Let's pull up the other one. And both these news reports are similar, but there's a slightly different information in them, and so I'll cover them both. They're both pretty short. All right, here's the first news report. Zoom this in. Judge, I think, can we do even better than that? Let's see. Judge drops murder charge against Philadelphia police officer who shot driver during traffic stop. And as we'll see when we look at the body-worn camera footage, by the way, this was no normal traffic stop. The suspect, to my eye, appears to be trying to evade the stop. He's trying to park his vehicle in a way that he hopes it would be concealed from the pursuing officers. It doesn't work, of course. And he rolls up his windows when the officers approach. He was driving really fast when he screeches to a halt, and the cops come out with their guns drawn already. Folks, I've been stopped for traffic violations. I've had my share of tickets, usually because the vehicle decided to go too quickly. But I've never had an officer come up to my car with their gun drawn. That's not a normal traffic stop. So there clearly was more going on here than just a traffic stop. In any case, Eddie Irizarry was fatally shot by the officer after he was pulled over on August 14th. A judge on Tuesday, so this would be yesterday, dismissed all charges, including murder, against the Philadelphia police officer who had been accused of wrongfully killing a motorist last month. So this is pre-trial. Last month would be August 14th. So this is only 5 weeks old, this event. This judge dismissed the charges. This is extremely unusual, folks. If there's any question in fact in a case, it's typical for the judge to defer to a jury at trial to engage in its fact-finding function. Really, the only proper grounds for dismissal would be if the judge concluded that even if viewing all the evidence in the light most favorable to the prosecution's narrative of guilt, it would be impossible for a rational jury to arrive at a verdict of guilty, then it's appropriate to dismiss the charges. You shouldn't leave a criminal defendant subject to the irrational conviction by a jury. Is that what the evidence shows here? So we're going to look at the video evidence, and of course there are claims made by the defense that, as you would expect, are consistent with a narrative of self-defense on the part of this officer. Mark Dial, the police officer who fired the shots in this case, pulled over Eddie Irizarry, 27, on August 14th before he shot him through the rolled-up driver's side window. Body camera video has shown. That's the video we'll look at in a moment. The video was played in court yesterday, but Philadelphia municipal judge Wendy Pugh ruled there was not enough of evidence to go to trial, bringing an emotional reaction from Irizarry's loved ones in court. Now, of course, you would expect the family of the suspect who was killed to be emotional about his death. That's normal. That has nothing to do with the legal merits of the shooting. So how they feel about the death of their loved one that's fine. That's their emotional response. That's not evidence in the case. That's got nothing to do with the law here, except to the extent that, of course, if the family is going to sue the police department, which, of course they are, a criminal conviction essentially locks in a civil settlement. Because if you're guilty at the criminal threshold, which is this much, you're certainly guilty at the much lower threshold for a civil settlement. So it's good for the people suing, for the plaintiffs in these kinds of police use of force cases, if they can get a criminal conviction. It's good for them even if they just have a pending criminal trial, because of course a pending criminal trial of this kind keeps the pot boiling in terms of pressure on the politicians who make the settlement decision. If to settle, when to settle, how much to settle for. Politicians are making that call. And politicians are always happy to spend other people's money, taxpayer money, to make their own problems, their own political problems go away. So the more pressure you can put on the politicians, the more money you'll get in the settlement, and the more quickly you'll get that money. So that's good for the plaintiffs. It's good for the plaintiffs' lawyers. So let's see. The defense of Mark Dial argued that Dial, 27, also 27, same age as the suspect, could be seen backing away from the vehicle as he opened fire, believing that Irizarry had a gun. The video showed that Irizarry had been holding a knife in his right hand. Spoiler alert, folks, when I look at the video, and we're going to go through it frame by frame, when I look at the video, I don't see a knife. Doesn't mean there wasn't a knife. But for this journalist to write this is inconsistent with my own view of the video. But you'll be able to make your own call when we play the video in a bit. Dial The police officer had been charged with murder, voluntary manslaughter, official oppression, and 4 other counts before Pugh dismissed all counts. So, of course, the district attorney in Philadelphia, again, is a George Soros guy. So, you're going to get the kind of politically motivated prosecutorial decisions that Soros pays for. Let's see. My thoughts are with Eddie Irizarry's family and loved ones today as they continue to seek justice and answers around his death. Mayor Jim Kenney said in a statement. So, of course, that's one of the politicians who'll make the settlement decision, urging the district attorney's office to do everything in its power to pursue justice and accountability. Prosecutors vowed to appeal this judge's ruling dismissing the charges and have charges brought against Dial again. Quoting now, the Philadelphia District Attorney's Office said in a statement, quote, the District Attorney's Office disagrees with the decision by Municipal Court Judge Wendy L. Pugh to dismiss all criminal charges against defendant Mark Dial for the killing of Eddie Irizarry on August 14th. Special Investigations Unit prosecutors will be filing an appeal of this decision to the Court of Common Pleas by the end of today. In keeping with our oath to seek justice and George Soros' money, we will move to have all criminal charges, including murder, reinstated against this defendant. So this is unusual that a prosecutor would do this, but of course this is a politically energized case, and I'm afraid Pennsylvania's court structure is a bit different than is common in many states. I've never practiced there. I've consulted on cases there several times, but obviously, there appears to be a way to appeal a dismissal at the municipal court level to the Court of Common Pleas, which is what the prosecution intends to do here. A notice of refiling of criminal charges was filed in court later Tuesday. So the same day the charges were dismissed, the prosecution immediately gave notice to refile charges, and the hearing was set on October 25th. So in just about a month. We're going to keep fighting, Irizarry's grandfather told NBC Philadelphia. This is not okay. The officer, Dial, has been in custody since Tuesday of last week after he initially posted bail and was released. So although he was charged with murder, folks, and it's not unusual for murder charges to be denied bail outright, he was given $500,000 bail and he made bond. So came up with 50 grand. Generally, you don't get that money back, folks. That's 50 grand gone. These things get expensive quick, but at least he was not in jail until a week ago. And presumably that decision would have been made by the same judge who just dismissed the charges. But in any case, since the shooting on August 14th, the first 4 weeks he was on bail, I think he made bail the same day or the next day. But last week, he spent the past week in jail until now, of course. Judge Pugh ordered yesterday that Dial be released. We've got another news story here. Let's see. Former Philadelphia police officer Mark Dial had been charged with first-degree murder and other offenses in connection with the death of Eddie Irizarry. In court Tuesday, the judge ruled the shooting was justifiable. The murder charges were dismissed. He was accused of shooting and killing a man in the city's Kensington neighborhood in August. Well, he clearly did that. I mean, that's not a mere accusation. The question is whether the shooting and killing was justified. On Tuesday morning, in a courtroom at the Criminal Justice Center, charges were dismissed against the officer, citing lack of evidence. It's an interesting way to put it, because the evidence of the shooting and killing is, I mean, no one's denying he shot and killed the suspect. So there's abundant evidence of that. It's uncontested. The question would be, is there evidence that it was justified? Can he meet his burden of production that it was self-defense? Remember, there's 2 burdens of proof in use of force cases. In the legal defense of self-defense, there's the burden of production and the burden of persuasion. So the burden of persuasion is what we normally think of as the burden of proof. Who has the burden of persuading the jury to their side? And in any criminal prosecution, the burden of persuasion is on the prosecution to prove to the jury that the defendant is guilty beyond any reasonable doubt. That's the burden of persuasion. But before you even get to the burden of persuasion, there's an initial step called the burden of production. The burden of production is the minimal scintilla, more than zero evidence that you need to get into court in the first place. In the case of the prosecution, it's that minimal evidence you need to get an indictment, to get the person dragged into court on a criminal charge. So typically in a felony offense, I mean, not always, it varies by state, but this will be done either by presenting evidence to a grand jury and the grand jury returns an indictment, or in some states it can be done by simply a sworn statement by the prosecution called an information. That's how Florida does it, for example. Like the George Zimmerman case was never put in front of a grand jury, his murder trial. They did it. They indicted him by information is how that's done. And information that was full of lies, by the way, in the case of George Zimmerman. Terrible. But so the prosecution has to meet its burden of producing that minimal amount of evidence in support of the criminal charge to get you into court on the criminal charge in the first place. But when it comes to legal defenses, the defense has the burden of production on the legal defense. So it has the burden of showing there's more than zero evidence to support, for example, a legal defense of self-defense. There's more than zero evidence on the required elements of self-defense. And if they can't meet that burden of production, if one of the required elements of a claim is self-defense, and those elements are innocence, imminence, proportionality, avoidance, and reasonableness, that's the maximum number. Sometimes one or more of those elements is legally waived. But if there's zero evidence on any required element of self-defense, then your conduct cannot have been self-defense, simply as a technical matter of law, right? Makes sense? If these are the required elements, there has to be some evidence for a jury to consider. If there's zero evidence, there's nothing for a jury to consider. And if there's nothing for them to consider, they can't conclude it was self-defense because a required element is missing. So the defense has the burden of production on evidence. So using the phrase here in this news report, citing a lack of evidence, well, there's no lack of evidence of the shooting. And there needs to be evidence of self-defense. If there's a lack of evidence of self-defense, then there is no self-defense. But of course, journalists are not the brightest people amongst us. In court, Philadelphia Municipal Judge Wendy Pugh determined the incident to be a justifiable shooting, which means, presumably, that even when she viewed the evidence in the light most favorable to the prosecution, which should be the standard at this stage of the proceedings, that no rational jury would be able to conclude that this was not self-defense. After the verdict was announced, well, it wasn't a verdict. A verdict is delivered at the end of a trial. There was no trial. This is just a ruling by the judge. If it was a verdict, the verdict would be two forms, right? Guilty, clearly not the case. She dismissed the charges, or acquittal. And if it was an acquittal on the merits following an adversarial trial, then there'd be no prospect for the prosecution to bring charges again. Double jeopardy would protect the officer. So there's no verdict here. There's no acquittal. Outside the courthouse, members of the suspect's family vowed to appeal the decision. Philadelphia District Attorney Larry Krasner vowed to appeal as well. Again, Krasner is a George Soros prosecutor. Let's see. Some of this is redundant. Let's see. Police body cam footage, that's what we're going to look at in just a moment, shows Dial firing his weapon at close range through the driver's side window of Irizarry's sedan during a vehicle stop. Dial shot Irizarry about 7 seconds after getting out of a police SUV and walking over to the car, the video showed. Dial fired a total of 6 rounds. And there's a lot being made on the internet about how many seconds it was before the officer fired and how many rounds he fired. None of those things are really meaningful in the circumstances of this shooting. None of them disproves that this was self-defense, but for some reason, people are making a big deal out of the number of seconds. Of course, everyone's coming up with their own version of seconds, but we'll be able to decide for ourselves. And they're counting from the wrong moment, right? If you're counting from when the officer got out of his car, counting the number of seconds between that getting out of the car and firing the first shot, that's completely irrelevant. Let's see. Defense lawyers called the shooting justified. This is why I wanted to cover this here. They said the officer, also 27, thought Irizarry had a gun, and that body cam footage shows the driver holding a knife by his right leg. Again, I can't see that in the footage, but we'll look at the footage together. Perhaps I'll see it on a second viewing. The judge in the shooting death dismissed all charges against the former officer after the defense made the case the shooting was justified since the officer had reason to believe his life was in danger. When police officers ordered him, the suspect, to show his hands, he instead produced a weapon and pointed it at an armed police officer. Defense lawyer Brian McMonigal told reporters, "In no world are those facts murder." District Attorney Krasner has called the videos crucial evidence in the case, saying they speak for themselves. That's one way of putting it. What they say when they speak for themselves might be subject to disagreement. DA Krasner. Okay, so let's do a little thinking here before we jump into the video. And again, I find the video evidence to be very ambiguous. I don't see in the video some of these things that the news reports are claiming are there. Maybe we'll see it. I'll do some zooming in and frame by frame as we work our way through the video to give us the best prospects for seeing what they can tell us. But when we're hypothesizing what facts would need to be present for this to be a justified shooting, it gives us a context of what to look for in the video and what burdens the defense and the state would have in making these arguments to this municipal judge. So, of course, in any use of force event like this, where there's criminal liability, you have two sides of the coin. First, you have the criminal charge, in this case, murder and other charges. And then you have the legal defense. And the criminal charge is murder. That, simplistically put, that the officer intentionally used deadly force against the suspect, taking his life. That's the murder charge. It wasn't an accident. It wasn't mere recklessness, blah, 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 blah. Intentional, cold-blooded shooting of the suspect. Okay, fair enough. Let's say that's the case. Let's presume that more than sufficient evidence exists to satisfy those elements of the criminal charge beyond a reasonable doubt. That's a guilty verdict. Unless that conduct, normally a crime, was legally justified as self-defense. If it was self-defense, then the conduct is not criminal because the justification wipes away the criminal liability, the legal justification. Well, how do we know if it was self-defense? Well, the legal defense is self-defense, just like a criminal charge has elements that the state has to prove beyond a reasonable doubt. We're presuming that's the case here. The legal defense has explicit elements. Those elements are innocence, imminence, proportionality, avoidance, and reasonableness. By the way, you can get this little cheat sheet for free, folks. We make it available for free. These are the building blocks of any claim of self-defense or defense of others. If you don't understand these elements, you can't possibly understand how use of force law works or evaluate whether a use of force might have been lawful or not. You can get this at lawofselfdefense.com/elements. I think I have a little banner for that. Oh, do I not? That would be unfortunate. I must. Good heavens. Lawofselfdefense.com/elements is where you can get that little cheat sheet. I guess I'll make one up. There it is. 5 elements of self-defense cheat sheet at lawofselfdefense.com/elements. So what are the elements? They are innocence, imminence, proportionality, avoidance, and reasonableness. To get self-defense into court at all, the defense here for Officer Dial has to show there's more than 0 evidence for each of those, that he was not the unlawful aggressor, not 100% evidence, more than 0 evidence, a hair, a scintilla of evidence is enough to meet the burden of production. It's very low threshold. That he was not the unlawful aggressor, that the threat he was facing was occurring or immediately about to occur, that's imminence. Proportionality, because he used deadly force in purported self-defense, he needs to have been facing a deadly force threat. avoidance, whether or not he had a legal duty to retreat before he used deadly force. I mean, he's a cop making a stop, so avoidance wouldn't apply anyway. Philadelphia is a stand your ground state, although it has a weird condition for stand your ground. I believe the party you use force against has to be threatening you with a weapon, which is what's being claimed here. And reasonableness. Reasonableness is an important one here, folks. It's always important. If you look at the self-defense law for your state, you'll see reasonable and some variation of that heavily thrown around in the statutory language, in the case law. In many statutes, you see a reference to reasonableness multiple times in one sentence. That reflects the weight and importance that the law puts on this element of reasonableness. And what does reasonableness require? This notion that your perceptions, your decisions, your actions in self-defense have to be reasonable. It's a required element of self-defense. There's no unreasonable, irrational self-defense. That's not self-defense because it's not reasonable. There's two facets to reasonable. One is that you had a genuine, subjective, good faith belief in the need to act in self-defense. And that's almost invariably present. Because the defendant will say that I was in fear for my life, right? That claim can be overcome if given certain facts, but generally it's simply the defendant making the claim is sufficient to meet the burden of production on the subjective half of the element of reasonableness. Well, there's another half, and that is the objective half. It's not enough to simply have a subjective, genuine, good faith belief in the need to act in self-defense. That belief also has to be objectively reasonable. A theoretical, hypothetical, reasonable, and prudent person would have shared that belief. If the belief is merely speculative, is merely irrational, is not objectively reasonable, you fail the element of reasonableness and you fail self-defense. What you did simply was not lawful self-defense. But here's the thing. Objective reasonableness does not require perfection. It doesn't require being correct. Self-defense does not require that you were right in your decision-making. Mistakes are permissible in self-defense as long as they are reasonable mistakes. So if someone points an object at you that a reasonable person, you perceive it as a gun, that's your subjective perception, your subjective reasonableness. You genuinely believe it's a gun. And a hypothetical, reasonable, and prudent person in your circumstances would also have perceived it as a gun. It's being presented like a gun. It's being handled like a gun. It visually resembles a gun. Well, then the law says you can defend yourself against it based on your reasonable perception that it's a gun, as if it were a gun. And if it afterwards turns out not to have been a gun, to have been a replica or a cell phone or a pointed finger or whatever, it doesn't matter if it turns out later not to have actually been a gun. It doesn't matter that you were mistaken in your perception of it as a gun, so long as your perception, although mistaken, was reasonable. So no one's claiming here that the suspect had a gun, actually had a gun. There was no gun recovered from the suspect. There are claims that the suspect had a knife, but arguably a suspect inside a locked car with the windows rolled up is not an imminent threat to a police officer standing outside if what he has is a knife. He's got to get through the glass. Now, sure, okay, so he could maybe break through the glass and stab the officer. But let's presume the windows are closed. The officer has his gun out already. He's got some reaction time. Let's presume for purposes of discussion that a mere knife would not be an imminent deadly force threat from a suspect inside a locked car with the windows rolled up. Does that matter? It doesn't matter if the officer perceived the knife as a gun. And that perception was a reasonable perception under the circumstances. So if you believe that officer reasonably perceived the object in this suspect's hand as a gun, and that's why he shot him, and of course, a gun inside the car would easily penetrate the window, right? Just like the officer's rounds did. Then that is a reasonably perceived imminent deadly force threat from the suspect against which the officer would be privileged to use deadly force in self-defense. And what could contribute to that reasonable perception of a gun? in the suspect's hand? Well, the totality of the circumstances. What led up to this stop? This was not a routine stop, folks. The suspect's car, when it pulls in, we'll see it's moving really quick, and it's looking like it's trying to hide. So I suspect there was a high-speed pursuit of this vehicle through these tiny neighborhood streets. You'll see how narrow they are. Is that felony reckless driving? Reckless endangerment? To be speeding a car through the narrow streets of a neighborhood? Something that the cops would be obliged to put a stop to pursue and stop that person who someone's going to walk out into the street and get killed by this car. Now, of course, we don't have evidence of the car careening around, but again, this is not a normal stop. Those cops get out of their car with their guns drawn, muzzle on the suspect. From the first instant, they're out of the vehicle. That's not a normal traffic stop. There's more going on here to warrant that kind of conduct from the police officers. By the way, I've seen news reports. I don't know the suspect's medical history, but I've seen news reports where they say this suspect's family describes him as suffering from schizophrenia. Now, the officers likely would know this, so that would not inform their decision-making. But would that medical condition, that mental condition, be consistent with someone who's acting irrationally with the police? It would, folks. Okay, so those are the elements we need to look at here. And of course, what the defense needs is more than zero evidence to meet their burden of production, get self-defense into court as a legal argument at all. And there's sufficient evidence here. There's more than zero evidence here. There's more than zero. And that's all that's required. Once the defense does that, the burden of proof shifts. Now the defense doesn't have to prove anything anymore. The state has to disprove that claim of self-defense beyond any reasonable doubt. The burden of persuasion is on the state to disprove self-defense beyond any reasonable doubt, which means the state has to disprove one of those required elements beyond any reasonable doubt. They have to prove beyond now they don't have to disprove all of them. Any one required element is sufficient to collapse the legal defense of self-defense. So what about innocence? Can they prove beyond a reasonable doubt that the officers firing of the shot was an unlawful use of force, that he was the unlawful aggressor, even provoking the fight? Can they prove that beyond a reasonable doubt? Well, the officer's making a lawful stop. I don't think anyone's claiming the stop was unlawful. Under circumstances where the officer's permitted to have his gun out on the suspect, I don't think anyone's arguing that wasn't the case. It's only about the shots. So this officer can the prosecution prove beyond any reasonable doubt that this officer was the unlawful aggressor in this confrontation? No, I don't think so. What about imminence? Can the prosecution prove beyond any reasonable doubt that the officer was not facing an apparent, doesn't have to be actual, an apparent imminent threat? Well, the officer's claiming he perceived a weapon, a gun, in the suspect's hand. That's imminent. What about proportionality? So for the officer to be justified in using deadly defensive force, the threat has to be deadly in nature. Well, the officer's claiming he had a reasonable perception that the suspect had a gun in his hand. Can the state disprove that, the reasonableness of that perception beyond any reasonable doubt? Avoidance is really off the table in these circumstances, so we don't need to worry about that. And reasonableness, again, and we talked about it at length already, the state would have to disprove, or would have to prove beyond any reasonable doubt, either that this officer lacked a subjective fear of imminent deadly force harm from the suspect, or that that perception was objectively unreasonable. Can he do that beyond any reasonable doubt? This trial judge, Judge Pugh, concluded after looking at this evidence that no rational jury could conclude that the prosecution could disprove any one of these elements of self-defense and thereby return a rational verdict of guilty. Any rational jury. Of course, we see unjust convictions all the time. That's just the way that works. And that's why she dismissed the charges. So now we're going to jump into the video. But before I do, I want to remind everybody that a week from this Saturday, on Saturday, October 7th, we're doing our Law of Self-Defense Advanced class. This is our full day course of instruction on use of force law, defense of yourself, defense of others, defense of property, an hour on interacting with the police in the aftermath of a use of force event. We only teach this full day class live twice a year, folks. This Saturday, a week from this Saturday, October 7th, we're teaching it, and then it will be 6 months. It'll be spring 2024 before we teach it again. This is a full 7 hours of instruction. It's all in plain English, the most comprehensive course of instruction we have outside of our instructor program, which is like a semester-long course of instruction. And this is the website for it, lawselfdefense.com/advanced. And all these red bullet points are the more than 100 specific issues that we address over the course of our time together. On Saturday, October 7th, we have a couple of packages you can pick from. One of them includes a bunch of DVD copies of the course, online streamed copies of the course, your state's specific law, which is a supplement to this course. And the other option is simply a straight up ticket. You can save up to 50% on these options. But again, it's a week from this Saturday, October 7th, folks. So this is we're coming up in the last few days to register. And if you can't make the October 7th date, folks, I would encourage you to register anyway, because we'll make the playback version of the day available to all of you who are registered students. So you can watch it over the next couple of weeks. Even if you can't make it on Saturday itself, October 7th, you'll have access to the content to watch over the next couple of weeks, watch a bit at a time. If you are present October 7th, this class is a fire hose of information, folks. So you can take the opportunity to refresh your recollection from Saturday, review parts of the course again, if you like. You'll have access to that recording. So again, Saturday, October 7th, full day course, lawofselfdefense.com/advanced. Now is the time to seize this opportunity. All right, now I have to see, how can I share the video? The normal StreamYard way of sharing the video was unsatisfactory to me. I'm going to see if I can share it as a using my video editing software. Let's see, share screen, window. Does this work? It looks like it's working. I'll make it a bit bigger. All right, so fair warning, folks, a person is shot in this video. So don't say I didn't warn you. Okay? There are portions of this video the shooting happens very quickly, the first few seconds. So most of the 8 minutes of this is post-shooting, and so there's blood, there's injuries. It's unpleasant. I'm going to skip over those gory portions. I'll put a link to the full video in the description of today's show for those who want to view the whole thing. I'm just going to focus on the few seconds that are part of the shooting here, but you may see some blood and gore incidentally. All right, so fair warning. I'm going to play it straight through from the shooting officer's, Mark Dial's, body-worn camera. It's only a few seconds long. I'm going to play it straight through. Then I'm going to play straight through the same shooting taken from a surveillance camera. I do have body-worn camera footage of the second officer on the scene, but frankly, it doesn't really tell us anything. So in the interest of time, I think I won't go through that in detail. But again, I'll link to it in the description of today's show for those who want to see it. Let's see if I can. Okay, here we go. Let's see if we have, this is, okay. And that's the whole shooting there. That quick. Let's go to the surveillance camera footage. We're going to go through this again at frame by frame, folks. But I wanted to run through it quick. Okay, so here's the surveillance footage. This is informative in part because it goes, I think it's evidence to the state of mind. We can infer a state of mind from the suspect here because he comes screeching up from the upper part of the screen, if we're looking at the left frame, runs over this traffic cone, ducks in behind this white SUV here, runs over that traffic cone. There's a second traffic cone behind the tree here. I think he hits that one too. And then he backs up snug against the SUV. I think he's trying to hide his vehicle from the pursuing officers. It doesn't work. The officers pull up next to him. And as they come around, you'll see his window is open a couple of inches. He closes his window as the officers approach. This is all non-compliant behavior, right? Attempting to evade the stop, attempting to, secure himself inside the vehicle when obviously the officers are going to want to be talking to him about his conduct. But let's go ahead and watch this. Guns are out. Okay, so that's just the shooting there. Now, a couple things I'll mention from this video, and then we'll go frame by frame through the other one. The cops come out with their guns out. This is not a normal traffic stop, right? We've probably all been subject to traffic stops because we, slow rolled through a stop sign or we're driving too fast. It doesn't happen at gunpoint, folks. A normal traffic stop doesn't happen at gunpoint. They're already alarmed. Both cops are acting the same way. So it's not that one of them is acting aberrantly for the circumstances. And he gets up here. He's saying, I will shoot you. So he's threatening the use of deadly force if the suspect doesn't comply, fires the shots, and look how fast he backs away from that car. He's out of reach of a knife already here. So if his subjective perception was it was only a knife, that would be inconsistent with his behavior here. His behavior is consistent, is evidence from which we can infer a subjective belief that there was a projectile weapon being wielded by the subject. That's why he's fleeing backwards as he is. That's why he's firing continuously 6 shots. That's not a guy who's afraid he might get stabbed. That's a guy who's afraid he might be shot. Now, do we know this with absolute certainty? No, of course not. We don't know anything. We never know anything with absolute certainty. But is this evidence from which a reasonable finder of fact could infer that this officer was scared of something more than a knife in the hand of a suspect inside a car? It is. And again, the state would have to disprove that claim beyond any reasonable doubt if it was attacking this facet of the claim of self-defense, the proportionality facet. That he only had a knife. He didn't have a gun inside the car. What matters is not what the suspect actually had. What matters is the reasonable perception. Okay, so let's start going through frame by frame. Hopefully this will work. So this is the body-worn camera of, you know what? I'm going to mute the audio for this because it's just annoying when we skip frame by frame. And I don't hear that much useful. So I had seen a reference where the defense claimed that the other officer, the second officer, had shouted gun. I don't hear that in the audio. I'll play it again full through. You can tell me. And I've optimized the audio here using software to try to find that. That doesn't mean it wasn't said, right? Because there are, the body-worn camera doesn't start recording audio for a few seconds, right? So we have that silent part at the beginning. But I just don't hear that in the video. Maybe the other officer is testifying to the judge. Yeah, I said gun. I thought he had a gun too. It could be. All right, so I'll bump up just a little bit here. So this is the shooting officer. He was in the passenger side of that police SUV. He's coming around the front of the bumper. He's got his gun out. Well, he's left-handed. He's got his gun out already, and he's coming around the bumper of the suspect's vehicle. There's the non-shooting officer there, also has his gun out. It's trying to open the car door. It's locked. Shooting officer with the gun in his left hand here, wearing an Apple Watch on his right wrist. In fact, I'm gonna rewind a little bit. So going backwards. So this is really the first look we get into the windshield of the car, right from about here, from the shooting officer's perspective. I can't see anything. I mean, I can't even see for sure there's a human being behind the wheel of that car. I certainly don't see any detail. Of course, we know there is a human being in the car. It's the suspect, the driver. And I can't see anything here that's very informative. And of course, what the camera sees and what the human eye sees is different. Just the way they capture light is different. How they respond to glare off a windshield would be different. The height of view is different. The body camera's on the chest, obviously here. And of course, the eyes are 1.5 feet higher. So just because the camera doesn't catch something doesn't mean it wasn't seen by the officer. Important to keep that in mind as well. So the officer's coming around. See, the window's open there. Driver's side window is open an inch or two. And it goes up as the officer approaches. So more acts of there, it's closing, acts of non-compliance. The officer goes to reach for the door handle to try to open up the door. It's locked, so he can't get in. So he can't open the door. And now I'm looking at this, and we're only a couple seconds from the shot, the police firing. I can't see anything inside this car. It's very difficult. Something is on the other side of that glass. I'm starting to see the suspect. Right there, I can kind of make out a face. Where are his hands? There's a hand. There's a hand reaching right on the left side of the screen, just below the officer's hand in this image. And it turns, so the hand's moving. It's not being held up like this, right? He's moving his hands in front of his body. I can't see a weapon here. It doesn't mean there isn't one. It doesn't mean the officer didn't see one. He says he saw one. There was a knife recovered from the vehicle for sure. The officer's shouting commands at him, right? Threatening to shoot him. It looks like it's the left hand, like that's the back of the suspect's left hand. I don't know where his right hand is. And there's some kind of movement inside the car by the suspect. I mean, that hand's not in the same position every frame. And there's the gunshot. So there's the first shot. You see the slide of the Glock is captured in the rearward position. That might be a piece of brass there, ejecting out of the gun, or it could be the glass, of course, is starting to shatter as the bullet goes through it. There's a broken glass. By the way, look where that other cop is. Doesn't mean the firing of the shot is unlawful. If you think the suspect in the car is about to shoot you, you got to put a round into him. But man, that second cop is downrange of these rounds for sure. And by the way, folks, if you don't know, when bullets go through glass, they can go anywhere after that. There's no predicting the path a bullet will take. It's worse when it goes through something like a windshield, which is much tougher glass than a side window or the plate glass window of a storefront. You fire through one of those, even with a rifle, you really have no idea where that round's going to go after it comes out the other side of the glass. But even side windows, pistol caliber rounds, I wouldn't want to be that cop downrange when this is happening. Okay, let's see. There's another shot. Of course, he fires 6 shots in rapid succession. There's the slide of the Glock back again. And again, I can't really see anything inside the vehicle in this image. So that's not evidence contrary to self-defense. I mean, again, because the camera didn't capture something, that doesn't mean it wasn't self-defense. If the officer is going to testify about what he saw, and presumably he did, at least through his lawyer. And those items were recovered in the car. So it's not just a speculative fear of a gun. There was something that could be reasonably mistaken for a gun, or at least sufficient that a prosecutor would not be able to disprove that claimed perception beyond a reasonable doubt, which would be the burden on the prosecution, provides grounds for the judge to lawfully dismiss. And when we look at, and I'll play it again through real quick here. I'll add the sound back in so you can listen to that again. Passenger side gets out, comes around. Okay, so when I look at Twitter, and this was really brought to my attention by a friend of mine. Some of you may know Jack Posobiec. He was having an exchange with someone. Where is that? Here. And it just highlights to me how people focus on just the wrong things. So Jack here is responding to another account. The other account says, the windows were rolled up and the door was closed. The officer took 11 seconds to make the decision to shoot a guy sitting in a car. Did he? Did he? So when I look at this, what are we counting from? From when the officer gets out of the car? So when the officer steps out, it's at 7.5 seconds. And when the first shot is fired, it's about 15 seconds. So we're talking 7 or 8 seconds from when the officer got out of the car. But the relevant point is not the start of the timing is not when the officer got out of the car. If we're looking at the justification for the shot being fired, if that makes sense, why not time it from when the officer got on shift that day? The relevant time is how long was there between when the officer perceived the imminent deadly force threat he was defending himself against and the firing of the shot? And that was probably 0.2 of a second, the time it takes to press the trigger. That's the relevant time. Not 7 seconds or 11 seconds or an hour or 8 hours. The question is, what was the officer reasonably perceiving that led him to make the decision to press that trigger? He's not claiming he was justified in shooting the suspect because he got out of his car 8 seconds earlier. So it's silly. I see a lot of people arguing, too, about the number of shots being fired. There's not a problem here with the number of shots being fired, folks. If you believe the officer had a reasonable perception he was about to be shot by the suspect, then you continue shooting until the apparent threat is neutralized. Pistol rounds are very underpowered in terms of stopping an aggressor. You don't know what your rounds hit, especially the first round going through the glass. You can't tell if you're getting solid hits on the suspect, especially shooting one-handed. You hope you are. But what you know for certain, in your mind at least, you believe to be the case, is that this person's trying to kill you right now. So you don't fire one shot and then wait and see if they've been neutralized as a deadly force threat. You fire until you have reason to believe the threat's been neutralized. Now, where people tend to get into trouble when they fire multiple shots is if they pause in the middle and then they start shooting again. And during that pause, they should have realized, a reasonable person would have realized the threat had been neutralized. Then the later shots would no longer be justified because there would no longer have been an imminent deadly force threat. But there's no such pause here. It's 1, 2, 3, 4, 5, 6. Perfectly normal. When you're shooting one-handed through glass on the move, trying to get away from what you believe to be a bad guy's gun. 6 rounds is entirely reasonable. All right. I do have a hard stop at the top of the hour. So I'm going to jump into our Law Self-Defense member chat. Still scrolling at the bottom of the screen there, folks. Our advanced course a week from Saturday, October 7th, lawofselfdefense.com/advanced. You can still save 50% on that registration. Last one of these classes we're doing for 6 months until spring 2024. Let's see. Law Self-Defense member Zach says, watching this angle, I can see how... Oh, by the way, if you're watching on YouTube, I don't normally answer comments and questions in the YouTube chat unless they are a $10 minimum super chat. So I'm going to look at these super chats in a minute after I do the members. And if you have a comment you'd like me to address or a question you'd like me to answer, then I would encourage you to make it a $10 super chat, or it will be invisible to me. And if you're willing to spend $10 for one question, I have to ask why you're not willing to just be a Law Self-Defense member, because it's dirt cheap, folks. It's normal membership is less than $10 a month, and you get all your comments addressed and questions answered during these live streams. And you can try out membership for 2 weeks, unlimited membership for 2 weeks for just 99 cents. That's at lawofselfdefense.com/trial for that trial membership. Or pay $10 for a super chat on YouTube, whatever you think is best. Let's see. Zach says, watching this angle, I can see how a cop would make that split-second decision that it was a gun, not a knife. Yeah, these things happen all the time in self-defense, and you're not required to make perfect decisions in self-defense. You're only required to make reasonable decisions in self-defense. Member Kyle says, the rapid retreat tells me a lot about this, about the officer's subjective state of mind. It certainly does me as well. Let's see. Jeffrey says, I think the cop was moving to open the door originally, then fires the shot. That tells you a lot. Yeah, the cop wasn't first shooting. He was giving verbal commands, and he was trying to secure the suspect with non-deadly means by getting access to the car. Look like murder? Not to me. Law Self-Defense member Andrew, great name, Andrew, says, when this was dismissed by court, is there anything more they could have done on dismissal that would give the public more facts to avoid the riots and reaction? Do the rioters want facts? I don't think it would make any difference. Is the media reporting the cops' side of the story here? I mean, a little bit, but they spend a lot more time reporting on the emotional reaction of the suspect's family than they are on the legal defense for this officer, right? So the media is not interested in getting out the actual facts. Yeah, I have a hard stop at the top of the hour because Wednesday is a BJJ day, folks. I got to go to I got to get to the mats. Okay, so that's the member comments and questions. Let me take a look at Super Chat, if there are any Super Chats on YouTube, and see what there is to say. Let's see. It looks like there are no Super Chats. Yeah, and guys on YouTube, if you can hit the thumbs up button, that would be nice. If you can subscribe, we just hit 50,000 subscribers this week, but we'd like more. It helps us trick the YouTube algorithm into propagating our content more broadly, which of course is why we are here. All right, folks. Cool. I think that's the end of today's show. So tomorrow I will complete my discussion and reading of Duncan v. Bonta. That's the Fifth Circuit federal trial court decision that California's standard capacity magazine ban is unconstitutional. It's a great decision. I read the first half of it yesterday. You can get that as watch the video or listen to the podcast version of that. Judge Benitez, I believe it's Roy, maybe Roger, I forget. Benitez, beautifully written decision. So I'm really looking forward to reading the second half of that tomorrow. Join me for that. And I hope I will see you there. And I hope I'll see you a week from Saturday at the lawselfdefense.com/advanced full day course on use of force law. With that out of the way, folks, I'll remind all of you that if you carry a gun so you're hard to kill, that's why I carry a gun so I'm hard to kill. It's why I carry pepper spray. It's why I carry a knife. It's why I'm finishing this show and heading out to BJJ. So I'm hard to kill. So my family is hard to kill. Well, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until tomorrow, I remain Attorney Andrew Branca for Law Self-Defense. Stay safe.